Various Models licensing Beutelspacher LL has recently incorporated trademarks, but the legal framework is haphazard, creating significant confusion for every party involved. Collect 20 trademarks are IP for Section 101 365 licensee has choice between interpreting or retaining its rights based on these ambiguity. The court does not decide every licensee has the unfettered right to continue using unclear licensees to require to make more agreements or such as available. Uncertainty these opportunities to provisions specifically trademark licenses. Therefore, licensors now consider uncertainty being and planning a strategy of trading Chapter 11 bankruptcy cases push to expanding resources and QC and drop their trademark risk loss of valuable asset. Ensure total market uncertainty by fragmenting IP law, destroying licensing agreements. Rossi and IT post-over rejectionists and hard trademarks legalizing or abandoning license selection problematic. These licensees do not have protection suffer damages and closed business IP law from different areas. Trademark by this will remedies and to new election markets and revenue which companies have come. The act has specific control from entering licensing for matter should be uniform to practices rulings without law and global IBD business. The mission is set to licensing enables the expansion of collaborative business ventures, which is unique for sports and college. 24. Licensing monetized brands to expand use, penetrating new market visibility, enter new categories overnight, giving media, presence new business or markets, small risk leverage, to target interest going value for licensing markets to support technology and incorporating increasingly viable promoters and licensees, retailers, consumer expectation for high ESG companies and hard investments. While licensing also articulated clearly the process has clearly articulated the process of cascading negative impact on business and marketplace, clear processing of details of significant partnerships are having potential to expand the issue of severe business rules financially strong relation based on trust. Licensing companies put out prices most major closing in the US transport opportunities enable advance to continue. Strong regime is the foundation of globalization. J23 globalizing economies in multiple countries. Presenting FPF licensing agreements crucial for international markets. Presenting be complicated without licensing misusing to law value and balance protecting brands for software companies depending international goods more or similar. Trademark licensing licensing help avoiding conflicts by protection for help Germany opening into new markets at different costs. Collapse triggers nuclear war, stalking manufacturing that enemies of drag consequences. Given equal actors including US-led orders that fashion globalization resulting in increasing stability and conflict between regional powers imaginable. Underscore classification policies affecting global food energy security points of view and new competition is many global hospital collapse and highly US crucial strength with globalization in the future. More complex globalization becoming a new trend tensions in Europe and Middle East, including escalation market global multi-level incompetence and climate change nuclear from humanitarian nations emerge. Following the US, the most recent credible studies prove slow 24 every move has a partner machine. Understanding political push nation building conflict and powers deeply trade beyond security and safety and anticipate positive respect and peace with Europe, losing the elite war making the DNA of modern politics, which is when both wars has significant benefits trade avoiding conflict, absence of wars since 1945, offers hope and improving commercial sports licensing enables credible US sports policy. The 24 the US sports policy must more than soft powers issues to bring nations together. Events receive objectives. US not too much sports part of US culture. The US events want to be useful and a popular environment to affect the influence and aggression cultural control is important. Plus, policy enables most collateral risk mitigation. Otherwise, extinction and extension nations once collateral hard globalization and technical issues, terrorism, competition, refugee crisis, influential policy requires benefits leaders face. Civil rights advocating last year requires retraction, persecution, partnership, software, third party authenticity, convention, every component contributed increase likelihood of culture, advice, disseminated the floor, political to reinforce public humanity, single by unlikely to agree, whereas wide geopolitical advice, however, possess qualities of collective good diplomatic to act as universal and trade development, playing field, political policy, more global and interesting to multilateral after requires more sensitive to cover more problems and enables different teaching practices at 117, licensing more things with pushes, substitution, producing, distributing competency bubbles, default teaching, electronic acid, addition, creating competency, and diversity, original teaching, exposes teachers, new brands, colleges, new 16. Exceptional users argue like training and college employment skills for countries sending measure from pioneers to low employment without field. I'll find out limited by lack of credentials. Smart education saves us extinction. Throughout T17, the education is special for society to survive. As an efficiency of ultimately fashion, applicable work loss vacancy, everyday teaching students, quality preparation, key mechanism, survival, innovation, application, inclusion, and education plays a crucial role in sustainable future. Innovation keeps evolving, CCC, so they can inspire the future survival or being dependent on education. That's the kind of government should strengthen trademark licensing rejection power. Amidst bankruptcy, and then introduce reorganization. Bankruptcy law fails to recognize the consumer welfare basis of trademarks. Quality control requirements are too stringent and unpredictable that deprives licensors the flexibility to reject licensing and bankruptcy, which deters licensing costs of trademark abandonment and tax reorganization. Only the plan to the need of ensuring market certainty by allowing licensors to reject certain licenses through uniform standard James 40 QC or the use of trademarks like high-priced quality must be made even when owners license person need licensing because of which hard change is serious in trademark being abandoned and policy nature. This is not most important to owners that they maintain QC course of various definition and balancing tests. Licensors must have sufficiently policing the specs of quality even after construction provision and clear how course expect licensors to exercise given increasing flexible entry standard, reducing move from there, from value use, the rejection threshold, minimum control user organization structure, profitability post bankruptcy, allowing license to retain rights after rejection completely deprived, detected license to rejection power, detected prevented by harms inherent and threat abandonment, where the physically untraditional, complete course not prevents consider allegedly a history, concrete source must follow nature, and economic uncertainty, and first form shopping would by the legitimacy of the code resulting caution, including unforeseen consequences results for licensees and licensors of amendment, allowing licensors to direct without fear, licensees retain rights to only specific conduct, dose, and possession control for quality, remain obligated to maintain quality, no claim, make licensing guarantees, licensors use rejection, licensees retain rights only without leave licensors open to claims active violate, licensees retain rights to dose, protection, control, at the time the rejection is approved, system files, party interest negotiation made binding prevents them from using support, make those cases support to unfair the compromise of guarantee, licensors contract with the solution provides a clear and predictable scheme, criminal language provides no equitable ruling, the possibility of making licensing is unique constraint, the 70/20 lack of adequate UC results from licensure relief through this agreement, licensors choice between extending the resource and investing locked and value by asset licensing, making the company less viable, your organization difficult to trade rights, specifically expending funds to maintain quality, increase imposing no less money to your breach of creditors, less likely to move the client. To get a fresh start, rejection is key after reform chapter 11, your organization becomes impossible, destroying brands, working 13. But the element of organization involving rejection of agreements and the matching out of inclusion termination operations require rejection and consideration for agreements on leasing PC holding out licensing require rights to marks with PC. The licensure has possible reorganization for licensure risk. The restriction of viable rights. Trademarks are being used by the CRE sector. Hail Law 24 IP consequential for CRE. In CRE transaction business become rely on running business potentially have licenses to trademarks customers for business to represent the brand and then the domestic bank defaults are incoming and unavoidable. The commercial real estate minus 24 CRE under pressure point in the US. The most biggest property market as we have down next year is the only rates on management series potential share the biggest police measuring the role and working contribute to stress price thousand office business by the default of those price observes that how does those make asset quality for pressure CRE market countries emerging pay forcing chapter 11 vacancy competition structuring size situation size more specific areas punch making to crisis capital competitors 40% of all those negative equity rises low balance default no default response all opportunity or HFC stress to review where failures among others defined as values in the clear loaded in order to withstand credit events risk essential for the banks effective organization is necessary to recover from debt defaults relatively unscathed. Chapter 11 about the economy, legislative defaults, bankruptcies that need to be structured into mental assets, section chapter 11, global consumption economy, this something about cultural liberty, profit claims, direct culture, investment motion, defaults in match now, globalization, inverted processing find out, new repetitive of chapter 11 legal process involved in adapting, increasing the experience, make restructuring more efficient, decline costs and nuclear war, which are out of 24 systems, small shocking, 15 points, resilience, vulnerabilities, and flight action, most of the risk of the risk as the key hostages, Ukrainians with power, economic transit, fighting hostilities, power step everybody, all risk, convenience, long-term interest, and incompatibility, conferences, contribution, complication, between the world order, basic power, best interest, species, civilization, trying major power, interest, and directly involved in using estimate, wisdom, independence, fiction, project, policy, of markets, even country, Korea, economic country, and NSA's control, anti-West sentiment, power for protection, fake, power, documents, and accessory organizations, preserves, sort of lessons, report. For companies looking to file bankruptcy, very possible to merge by future public investment to be multi-million companies are those of value reports are looking to those are necessary to enable the sharing economy. Last 2020 called it according to the current Chinese still participate in sharing affordability, reduce consumption, enhance success of being suitably ability to share the suitably ability to sharing economy, entrepreneurs also marketplace for use of purchase trust and crucial buildings, eligible center for exchange, land always increasing use sharing goods, particularly expanding next emergency distribution, use tech to impact with automated processing processes are being to the future, reduce mobility and access to resources, solves extinction law for 30 and the American CIC sector comparison to legacy economy is like a failure to allocate shares resources to the environmental collapse every day to unsustainable resources, more interest, and to us like party has to be the extinction must be facing extinction with the speculated down to SE, drop by the downside of the death economy, sharing group households, those who need MNC strive, emerging direction of wealth inequality, and the startups are crucial. The FC24 is sharing economy, new concepts and gains significant momentum with the sharing of rising of sharing economy, startups communities finding innovative ways to sharing economy local communities.
Okay. Great.
Yeah.
Great. I just want to ask about the plain text. So, strengthen trademark license or rejection power. Are they able to do this in every instance, or are there exceptions to it?
Not in every instance. They can only reject licensing contracts if the licensee does not do quality control.
If the license doesn't do quality control?
Yeah.
What part of the plain text says that?
It's strengthening. It's not complete strengthening. James specifies that licensees retain rights only to specific products, those in possession and control for quality.
How does the court determine whether something was like quality controlled enough?
It is going to be baked into a contractual provision that is in the rejection process.
Yeah,
and it also says that it does not have to be completely quality control. So the issue is just that the legal responsibility shifts to the licensee. Whether they actually do the quality control or not is like, they have to because it's the law. But if they don't, then all responsibilities and costs will go on to them,
whenever
not the licensee.
a licensee and a licensor make a contract with one another, there has to be like a provision in there that's like, you have to do quality control, otherwise we can reject it?
No. I think it's not part of the contractual provision. issuance. It's just when they reject, the legal responsibility is shifted onto the licensee. So nothing about contracts. Sorry.
Wait, okay, so then who is requiring the licensee to
The courts.
mandate quality control? And then how do they determine what counts? You said it's part of the contract and it's also not part of the
No, it doesn't really matter what counts because any costs are going to be shifted onto them. So whether they do it or not, it's like
Wait,
entirely
it doesn't matter what counts, what's the purpose of having a quality control exception?
because that burden is no longer on the licensor, which we say is burdensome.
Okay, that sort of makes sense. The first advantage is the only internal link just like certainty in the law.
Yeah.
So then why are like quality control exceptions key to that?
Quality control exceptions are key because they say exactly which instances in which licensees are allowed to continue using the trademark.
I mean, but it still seems unclear. Like, I mean, you're
It's
like,
not unclear.
don't really know.
They can do
Could be
quality
some
control.
instances.
Like they are allowed to use the trademark, except if they do not quality control, then all the costs fall onto them.
But it
Status
doesn't
quo
really
is far
matter.
worse because there isn't even a quality control provision. You have no idea in what situations or even if licensors are allowed to reject it. And every court decides
Yep.
about it, which is the entire point of our unique argument.
Okay. The like econ impact, the internal link is like companies that are about to go bankrupt or have already gone bankrupt. Why are those key to the economy?
Our Barnes evidence is really good on this. It says those companies, and they're going to collapse banks because banks, like over half of all of their loans are invested into commercial real estate companies that are going bankrupt. If those companies do not survive bankruptcy, then the banks are going to fail, and that causes runs that
Wait,
will surpass the levels seen during the 09.
How does the plan give those companies like more money to like get out of bankruptcy? It only
The
gives them
trademarks
trademark.
themselves are the money. Like there's where the money is at. They're losing money by being forced
By
to
not
quality
having
control
like
that is a burden.
authority over the trademark.
If they have to quality, if the licensor has the quality control, they lose a lot of money. And if they don't do quality control, they also lose the trademark, which loses a lot of money.
Okay.
Wouldn't see the Senate.
Yes, you're right.
Is 6 and then the case.
Case was 1, 2, 7.
Yep.
Cool.
Let me know whenever it's good.
Give me 1 second. Yeah, we're good on issues. Good. I'm good.
Alright, Forslund, you good?
First off, applicability measures protection is solely includes coverage or treaty duration, enforcement restrictions, parking, research and policy makers and stronger IPR miracle with offer precise. On the sum of the 5 scores are coverage, treaty duration, enforcement restrictions, this index is an indicator strength of patent possession. Violation plan is about contrary rejection to means none of the outlined ideas is the preferred limits it was protecting any tangibility related right and its subject grounds it lift coordinates and counterparts which are aligned on the 5 and is not related to rights next up is CSR picking IC federal government requirement the license or trademark reducing granted except when it violates the social corporate social responsibility due to respect of the directive finisher due to the basic social rule. It commits to benefit the counterpart and to make it always strengthening the rejection power by releasing fisher during the counterpart mandates a weakening IP rights by removing the business judgment rule, the legal mechanism that forces a director's duty to protect IP is under 16. Because IP assets and copyrights a high percentage of company value, the management falls within the ambit of a directive fiduciary duty with the director adequately managed corporation. IP is going to be deemed to breach by fiduciary duty on the BIR. There occurs a difference in the board's decision as long as the director fulfills the duties of the director because he could face scrutiny in the class action lawsuits or shareholders argue the director's breach of fiduciary duty by not following the protection of large class actions and possible appointing for the directors. Considering IP, the Catamount Solves organization, YC James rejection, would function deprived of debt to license or rejection power because the resident trademark abandonment fails a business judgment test. Also sells licensing collect 20 debtors. Licenses are not considered uncertainty the planning strategy of the Chapter 11 bankruptcy case issues with standing spending. Scarce to the QC and rep of the trademark racing. Loss of assurable asset that shareholder primacy, loss and convergence of X-century ecological crises, extinction point 20 cycle corporate pollution, corporate solution is repeated around the world strategy has been argued against the point of before the 5 largest oil corporations invested in 1 billion misleading climate lobbying since Paris is used to block policy and climate financial projections. Assume the continued profit of 5% increase in time they plan future really companies survive long in the US agreed that would be limited in corporations crossing economy, not just ending energy, adding the unlimited corporation to be requisite environmental degradation. Existing the corporations, DNA shareholders Owning an investment should be responsible to damage corporations with this capacity for destruction will be solved by 2 great meetings and the corporations that can remove the rights and the privileges of owners and shareholders to get rid of corporations and super survival kills of corporations before it kills us. That stops extinction. Windsor, Waker, 21 broader issues looms. Our world is diseased and the crisis will follow. Serious harm mitigating the effects of climate and sustainable with the environment and health. Corporations unique leverage nothing else matters. The planet's resource crumbles is that there is urgency to scope this unlike society based on sustainability is an only issue that presents a threat of the existing society is linked to many a chance to be joining corporations to achieve progress in biggest extension of that. Next up is the common law accountability, excluding any reference to the laws of the United States. The United States government fiduciary ought to hold that the judicial president requires strengthening trademark protection, licensing rejection power, amidst bankruptcy, the legislator and relevant agencies should defer to this interpretation without strengthening their protection and intellectual property rights. Competes and solve English. 22. Common law IP refers to judgment action that requires the rights enforceable through appropriate liability. IP relating to patent, copyright, and trademarks, etc. The Congress alone is authorized to modify common law statement when exclusive the rights of work and the defendant's wrongdoing, despite having independent existing common law overlooked society, but still a solution can be derived from the common law interconnected to multiple license. Common solution can be derived from common law interconnected to against overcoming complication of IP statutory. IP can be derived in common law, introducing common law, and includes developing rules that guide common law, IP, superior potential IP, and so on the development, of course. Judicial law has obvious change to IP law, the course, to proceed limiting given opportunity to nature, the change it occurs, recurring obstacles to the judicial law, opportunity, experiment, is not the rule that lowers, based in contrast to legislative interventions that require workarounds. That current legal precedent constraints federal common law. Note 15, judges feel free to recognize Congress to federalize in the area, but to provide rules and decisions to all modern issues. Modern churches deny the law can operate both the federal law, but the concerns are often the rules and decisions has analogous path to legislative exercise. Scalia has drawn the conclusion that no decision against common law, every issue involves interpretation of common law to external and internal sources that might conclude the court's need to grant a justification, including unless a court can appoint a specific delegation of lawmaking power, the court should not purport to the articulate rules of common law. Federal judiciary has taken a position sort of unless it's written in federal law. Mark their heart at law. That's not. Let's first climate mitigation, extinction, evidence. Ever 2019, global warming, the most pressing problem at a time affects our common law served as a vehicle readjusting environmental harm. States use common laws to seek to redress pollution by polluting emissions. Federal common laws uses regulatory impacts from common law to protect citizens from harm. Next up is the election CA. Harris wins, but it's close story. 2010 to 22. The string survey show Harris advantage. Harris leads to 50 to 46%. The road is found Harris 3-point lead, 5-point advantage. Harris college poll of likely go to CBS 51%, 48%, 49 to 60 to 46% times. Sienna race Trump's lead. The entire Democratic voting bloc, despite the strong IP, Henry 22, PP, Democratic lawmakers pushing proposal use march of residencies, patents, rights. Left one have government seats rights. The election will depend on tiny shifts. Score 1022, very close election reflects equally divided electorate. Small demographic changes wind up being big. Small shifts in electorate can make a difference in post election since 2003 to make a difference. Well, from tiny shifts in one direction that levels to higher. That causes extinction from 10 to 2.0. Verse 23. Trump's attorney would have more drinks a second time Russia, China, and North Korea. America needs a leader who think meaningfully provide prove irremediable system failure, hasten the sudden and anticipated nuclear war from the blue on national security, establish system failure, the government, mutually forced to involve WMD America first becomes our and irreversible America's first onset of worldwide nuclear war. Next up is the U.S. Code Counter. The Office of Speaker of the House should request the Office of Law a revision council revisit codifications of title of the United States Code. The office should insert a no source provision in the 15 U.S.C. Section 1051 to 1141, clarifying the trademark legislative rejection power of bankruptcy ought to be strengthened without strengthening the protections trademarks executive and judiciary should refer the interpretation and convenes to solve 234. Hospital law consists of enacting law that goes in session regulation applied to the cortex, and the U.S. Code of primary capacity and evidence of the law. This language is not a page of the judiciary means lawyers with the risk of relying on 15 CUSC instead of blended back the current communication of Title 15, Journal about ORC and Congress. That issue with the request of ORC clarification, so also that changing parts of law with politics and temporalization, cross-running codification of ORC may change or insert the substantial provisions that clause perceiving and changeable the acts of not enacted the law. Congress is not voting a little interest in statute and kind of the public. Preserving the reasons that include time, expertise, avoiding accountability, bureaucracy, show the commitment to non-partisan Congress is written into rationality, the institutions that procedures strong, more durable system, market counter system, extinction rebellion. 20. Society called upon more flexible cooperative systems as item highlight the need for vigilance to protect peace and knowledge of the saving theory. War and WD, COVID president connector, president, access to which world system can be open partisan. Politics have effective responsibility harder for world tactical existential threats of the zero climate and nukes. Now the case can't solve this isn't about the plan they strengthen. Global trademark licenses or rejection rights, they don't give licensees. The trademark owners that go bankrupt. Additionally, all causes making part of IP law. To clarify all IP law assets to as licensing agreements. Obviously exists now. The number of businesses that might go bankrupt is minuscule and aren't producing the most economic value. They would fail in every all causes they can prevent businesses from facing infringement. When expanding abroad, the no trade impact is obviously empirically disproven, and countries have incentives not to tax supply chains because it hurts themselves. Now the globalization trend is breeding ground for more terrorism. I have 28. Globalization breeding ground for extremist groups using ecosystem charges to get identity, emotional goals, the sharp pursuits, and connected bond transportation, increase terrorization, national trading capacity, boundaries, organization, organization. That causes extinction, legal war. Verse 21. WD nuclear services resource itself defense to be nuclear any resort of one or several sites for catastrophic planet. This trade fragility is a person that compares to make a single miscalculate accident in the world as though whole has been separated or terrorism could propel a continent to the nuclear war. No sports diplomacy, no internal link. Why does it solve any of the impacts they cited? They just highlighted random parts of the card and assume that it's solved. They need an actual explanation. No education impact makes no sense. People still attend college even if they don't have strong trademarks. No red line for how much education key. And other countries will obviously fill in or uneducation in other countries' thumbs. Now the reorganization advantage. No solvency. The plan does not bail them out. Only bless them to end licensees when they're bankrupt. COVID and made them the impact. And the plan doesn't cause war because countries know they're weaker and they wouldn't want to hurt their own interests because it would destroy their economy. Zero now sharing economy. Zero evidence of startups who go bankrupt are key to sharing economy. Other successful startups are better. And saving unsuccessful startups causes a zombie market which destroys the economy and causes their impacts. No inequality impact and environment impact is straight turned off the counterpoint. No impact inequality. Area 16 affects inequality in border countries, higher economic divisions, example weak relations, not even borderline significant interaction affects inequality, preference significant using multiple regression, right the card and aggression, no populism impact, self-correct, strain 17, self-correction, strength, church studies 800 elections documented populism, evidence now curses, people dissipated after curses return to normal years. Now localizes global causes, climate activism cancel, literal nuclear war, they need to explain this controlling, we get new answers.
Good cross.
Status?
Actually, the second one. More.
What? Oh, sorry.
My mistake. Good, yeah.
Status?
Conditional, begin,
benefits.
assess, was option. What was the question?
Net benefits?
Pranav.
Okay, sorry.
Is everything internal?
For the CSR counterplan, it's just internal. For common law, it's internal and elections. For US code, it's internal and elections.
Internal, just we discussed. Cool.
Uh,
How does the first counterpart compete?
Which one?
CSR.
Okay, so the plan mandates clarifying the license or rejection power in all instances. I mean, we think the plan text means this,
Wait,
and
why?
we can make arguments
What word
against
is
why it
it?
does.
Well, let me
Like,
read the context back to you. The United States federal government should strengthen trademark license or rejection power against bankruptcy. It says this
We
has
think
to
that
be-
means that trademark licensors would be able to reject licensing agreements when they're bankrupt. It says
In every
strengthen
instance?
the rejection
Wait,
power,
what?
and it
Okay.
specifies the instances in which that occurs as amidst bankruptcy.
I
It
know,
means that in
what-
every instance that a licensor is bankrupt,
So
they get to
what
reject their
definitions have
trademark.
you read that this means in every instance?
I mean, the donor card explains the way that the plan and counterplan interact, but
I don't think so.
we'd also, I mean,
It's just a
of course, we'll read more in the 2C.
Okay, so as of right now, just to clarify, you have made a grammatical argument about the
Uh,
syntax and the plain text, and that is how the counterpart competes.
I mean, yeah, like we made a
Okay, cool.
specification.
Can you explain the donor card?
Which one?
Donor.
Yeah, the donor card says like how it currently operates is that sorry.
What is the business judgment rule?
So business judgment rule is basically immunity for businesses if they do not uphold like their shareholder value or they don't predict value for the company.
Okay.
We think the plan would uphold that, and this is like a pick out of them having to do that.
The business
Why is
judgment
it-
rule is the thing that currently prevents licensors from being able to reject licensing agreements.
Okay.
If they did, then they'd get sued on the basis that they violated the business judgment rule. Instead of doing what the plan does, I think
What does
just
the plan
removing the
have to
business judgment rule and
What
replacing
does
it
the
with
plan
a
have to do with the
CSR
business
solves.
judgment rule?
The first card on the second advantage talks about it.
I know it does, like it says the words, but I didn't say that in the ones. Like, okay, so even
I mean,
if
it
they
explains
speak
the way
about
that the
it,
plan would
yeah.
interact with the judgment rule and how it would uphold it.
The second sentence right after that is talking about harms inherent with the threat of abandonment. That is separate from the business judgment test. It is just about trademark abandonment and how the DEX reorganization chances. How does the counterpart solve that?
It says, to the extent that the proposed rejection fails the judgment test,
The sentence after.
even if the state would benefit from the rejection, the debtor may be prevented from doing so by the threat of abandonment.
Yeah, that's a
So it's talking about, like, it's explaining the implication of the business judgment law.
Still have no idea what this is.
Again, it is literally immunity from liability when like a director has violated a duty of care. Duty of care is something that the policy outlines as the increase.
Okay, and your argument is the plan overturns.
What?
Your argument is the plan has to overturn that. That's how the counterpart means.
Not overturn it, the plan has to sort of support it, or like.
Yeah, it was
So
it
yeah,
would increase it.
yes. You skipped over very sorry, sweet hands, right?
Yes.
you just get Bailey on the bench too?
Yes.
Send the dog. Give it to you.
The order is going to be the licensing advantage, the reorganization advantage, T, the common law counterplan, the what they call it? CSR. Yeah, the CSR counterplan, CSR counterplan, the OLRC counterplan, and then the elections to start. Anyone need that again? Cool. Anyone know? Bet.
Yes, sir, Turtle Lake, the rejection rights and plan grants clarifies the contract of both parties, which is the key bill after this aspect, which is our draw to Turtle Lake evidence. We don't need to solve all intellectual property law because our evidence is highly specific to trademark licenses, which is all we need to solve. The licensing agreement's existence as quo, but they want to expand, which is what our evidence says is key, and our small scale now is question potential bankruptcy, which is what depresses all licensing agreements in the status quo. A broad infringement is solved by this license now, to them because they would rather not be under the constant threat of Interpol intervention and globalization threats extinction is offered sought. The evidence that says that every hotspot like the SES, Taiwan, and us are prime for escalation of the status quo, only an economic piece instead. The trade prevents it from going nuclear independently. They also thought that it's an impact filter because it allows the provision of global public good. The term is wrong. No nuclear. Miller 22. This is increasingly evident. Tertiary is going to remove desire. Unless targets going to come in for the government. Evidence is likely to buy a bomb time and follow the right to be made. The social community determinations are serious against the community device of the building point and everything challenges the building acquired. No requirements like material purity. She seconds no link to never for other countries. Other scenarios reversing U.S. connections and non-EU globalization. Other countries trade ensures all the terrorists threats independently right. When extremism is wrongly applied for reasons besides globalization because it's domestic media. 3 4 is all possible about the internet. 1 2 many background in all the social green park for variety of the internet age on the construction and pressure. Then attacking New Zealand. They have and the sports will be yes, so the sports will be internal link. Our sports are exported internationally, which will be a license agreements. Yes, impact our evidence says that it creates a avenue for multilateral cooperation. That is an alternative to going to using military force. The quality of college is irrelevant. The quality of college is key. If it's low quality, which means that nobody gets educated. It's literally a linear impact because worse education means worse innovation and less progress than large. And the American progress is key because that's where our evidence is about. The second advantage. The plan allows them to be organized because the lack of quality control is what the cube block is now, which is dropped. COVID and 08 are examples because what allowed us to get out of 08 was chapter 1 bankruptcy, which is failing in the status quo. COVID was a global decline. Our evidence is about relative decline. Does cause broader than dropping within our cards. Our Wishart evidence says that revision power state power back needed to use it to escalate nuclear. And our John evidence says the U.S. lashes out, which causes nuclear escalation. Startups are key. They're going bankrupt now. Successful startups are good as for all of our evidence. Zombie market is uncarded and they recover and become good companies again. They drop the sharing economy impact and over consumption, which causes extinction. It's key. We strengthen coverage to those who have bankrupt. We increase duration because of persistent threat of bankruptcy, increase enforcement of quality for and restrict license use. We need level of vacuums, the only objective metric, strengthen coverage by powers acquisition, scope of revenue, stability. Ladies and gentlemen, copyright user require products to the work strength revenues, but for founding new path innovation, precision, the revenues sometimes stronger, not strengthened. It doesn't have the intent to exclude word or better because we say literally every ruling and law has ever passed on limits the literature basis tiny impact terms of generic core club, all restrict outright increase abilities to quality. It's not particularly the common law kind of unfriendly plan over bankruptcy might accept the tax independently. It's legitimate because that's using additional function at work and was intentionally function type of speed or great range. Longevity and headlock cycle. Otherwise, we finish the conflicts. Kill outbound part of the terminal of the plan. Should refuse the feedback. Hey, should those confusions possible events. Turn to both things small one account one. Fails once licenses are in here, potential licensing rights, related to licensing agreements, which is key to international market expansion, globalization, Dustyn, and Daniel. Specifically, only clarity of process sustains globalization. There's a long evidence. Second is license surrender is key to the strategy of the debtor reorganization, which forces them into decisions that delete the trademark or valuable resources. Necessary for reorganization, which are Clark and Gethsemane evidence. 3 is legislative clarity is key. Every time the court follows the U.S. code in bankruptcy interpretations, not previous court rulings or precedent uncertainty leads to circuit splits and model interpretations, which destroys rejection rates. And trademark licensing under James Zarowski and Clark evidence. The court decisions inherently paid uncertainty. 2011, the legal solutions are now with all the ways in the computer and reducing reduce the laws, efficacy, the court of course, legal ideologies. There are internal forces that are actually important because some justice robbery. Political arbiters that place a lot less. I don't come to the counterpunch is advised not saying versus the only losing arbitration courts was that is very important. And legislation should design to make application of like an often like recognition of just over one instance of common law does not mean that we use broadly to show impact and launch list of no war for extinction to essential climate tax. 24 the application portal these are not allowing that and also how important actually exists according to could be 1 degree 2 degrees of like worst case alarming accuracy of course for 20% low confidence any change and unfortunately quantum drive fire absorb the emergent delays there for radiation and general activity and the longer scenarios are unrealistic or will be moderate and not just the word rate of comparison also short range such as the expensive the definition of non-common factors is grossly inadequate of the ever body evidence about what we have access and actual very graphic detail representation and zero should to be unnecessary that the fact that the development of an impending disaster that should be addressed through adaptation to CSR kind of on first and kind of on fails and not solve licensing. It does not give them a right to kind of manage the licensor. The only part that can determine whether or not the licensing agreement survives that shows licensing makes every single impacted member. Obviously clarity is insufficient. If you take every single power of the licensee obviously crushes advantage 1. Second, the actions and effect revitalize corporate social responsibility. There's a lot of evidence. It's a 1AC scenario for innovative based on a reason. Contractual provisions engineer and guide corporate responsibility, which only the plan is able to solve. 3 is can't solve reorganization, rejecting power and quality control are key. When see James and see with the confident intent and everybody critiquing some of that from just the red of abandonment and words permanently the counterpart. Caused by the T definition of the counterpart so mandating the increase in rejection power and currently both permanently the counterpart of the planet and heard the plan and repealed the business judgment test is not intrinsic as part of the counterclaim. Otherwise, it's written the counterclaim does not repeal the rigid advised business judgment rule, which is much broader than bankruptcy. The overall environment is resilient. Daily 20, according to actors, catastrophes, appeal, civilization, measure, bond, and exaggeration, powerful laws, and the judges relates to it. And multiple murders of the rate. The economic is not the end of the world. When the strap has an announcement, she answers on the long stars. Have defined it. Not human is inductive. We will continue prosperity, technological progress, workers. The trend is that it's part of the plan and counterclaim. And to declare rejection is socially irresponsible. It's not intrinsic because the counterclaim already mandates rejection violates the CSR. The firm is a clarification counterclaims. It's the cross-line justification of. And it is not all Oxford language no day. In the middle of. Okay, cool. Causes voting, she wants fairness, and it removes often checks on the complaints, choose bad basic person, and stressing testing the US alternative to solve we can kick it. Only from you to not caught theoretical objections already. The LRC counterclaim, current to the plan, and plank 1, possibly all the objections from the common law counterclaim, no from the counterclaim, non positive titles of the force law, overseen no debate. Notice about the titles of the subject matter, non-positive law, direction, non-positive law titles, non-positive law titles, both these all students, the result of the laws, non-positive law titles, and separately. Next section, counterclaims also absolutely nothing. Age authority over the LRC has only power to clarify and reorganize code, not to enact new policy. That's our own evidence. To one and see cross, to clarify persons, international definition, ensure the internal LRC state had a more powerful will cause more vice than also to receive as liberal hijacking democratic measures. Please strike down the number 20. Statutory rights are more than law, that is separate race, statutory discussion. Those are valid law enforcement. Treasury has a set of grounds, no plan, no idea, no provision, there was as a provision that pushed out into the chapter like the system makes it fine. No to understand important terms and count on the plan is just still over because one instance is not able to solve all professional fights because we empirically insert a time in which their evidence describes the plan solved by partisanship because it makes me go because it makes people agree over the plan and cover the counterplan, turn the plan to counter over bankruptcy, tax insertability, elections is event, once Trump wins down that plan, and say Trump is that problem because there's 3% of the errors with the legal success of Trump. Trump will cover again because Trump will do reserve couple lines to see what they're expected by the again. Trump victory, second is that it's too late. It's like literally like 9 days after the election. Nobody would flip votes if they were going to. Then it would certainly not be over trademark bankruptcy law, which is such a small subset. And nobody cares about Trump will cheat on 24 Trump. For them, votes not intrinsic to the plans are Trump that maximize the loss of reciprocity. No link. Nobody cares about the plan involves 24. Minimize pollution. Trump that chooses pollution for Trump is ready to Michigan. No national practice relation. Controls fully the laws of the gas guard grocery business. I believe they will forget because they would just forget because there will be closing arguments that are done to assume and Trump will train press 4-3. Congress supports the religion of president Biden will follow the content. So long as we could just around the train by himself and day for all the workers and power law to multiply. For so long Trump is just one of those like actually office and legislatures with they how down to these criticism. Translate in a policy, there's no link or evidence not about the app specifically, which is where we should hold into in order to have any kind of internal into this. I don't know, where do you hear your friends? Yeah, I guess. Sharing economy enables sustainable cities, thank you for 16. Please leave it along the ranks of the global economy, Syria economy, Alberta, urban regions, living, consider the freeze, cost matching housing, host of energy, and helps cities save costs by 40%, over sharing, better cities more attractive price, housing, vision generation, that would develop local economies and market part of economies, make city concentration, 60% by the nation's rate, digital revenue, the overall energy, trillion tons of water, considering benefits, research, very existing benefits, very sounds, no existing one also digital research, research, and then probably very good place, bringing nice grant solution, and face the future urban and growing diseases, only land, and in trouble. Are in trouble.
Good for cross.
Yeah.
Reasons to reject were just the condo index.
Yeah.
That's it? Okay. Now, the case. Why, why don't other countries fill in for education? Why doesn't that solve
For
it?
education? Well, our evidence is specifically about the American collegiate system.
Okay, how
And
does the
also,
American education
American
system
college
solve
is
this?
unique. I mean, the reason that so many internationals go to U.S. schools is that it's far and away the most robust education system where talent tends to concentrate.
Okay,
It's
why is
the
that
argument about
uniquely
brain
self-extinction? Because
What?
your impact card is just like education self-extinction. So why is the US system uniquely key?
Well, because if we have uneducated policymakers and a lack
Wait,
of...
so your argument is that only the US is like educated enough to make policies?
Well, if the U.S. is uneducated, then that kind of removes the benefit of other countries, right?
Okay.
If the global superpower is run by idiots, that
gotcha.
obviously triggers all our
Okay,
impacts.
gotcha. The common law counterplan?
Sure.
You said like each type of court follows US code, not previous court rulings. Where does your evidence say that they don't listen to court rulings at all?
Well, the argument that it's making is that when adjudicating bankruptcy disputes, they defer to the bankruptcy code, right? The argument that they would follow court.
Okay, what evidence do you
adjudication,
have that they wouldn't listen to precedent or rulings?
It's all of our evidence that talks about the uniqueness of
Pull a
the
line.
mission rule, right? It's
Could
created
you pull a
circuit
line
splits.
from this insert?
Sorry, what?
Could you pull a line from this insert where it says they wouldn't listen to a
Sure, I'll
ruling?
pull a line. Give me a second.
And remember, wouldn't listen to a new ruling.
Yeah, for
not
sure.
just
I'll get you a line. Give me a second.
Where language is clear, judicial, complete, courts not permitted to consider
Where?
legislative history. Courts
Well-
not permitted to consider legislative history. Congress and courts must follow.
Well, where
Legislative
does it say they
history-
wouldn't listen to precedent?
They're not permitted to consider legislative history, which is not
That
law,
was-
that is
it's not
courts.
legislative
Courts.
history. That actually contradicts your argument because you said they listen to
Okay,
statute.
I'm gonna look you up the definition of legislative history. It means,
Legislative history?
it does
Legislative.
not mean the past rule, it means.
You said they're not
evidence
permitted to
describing the
listen to
progress of
legislative
the-
history,
the
right?
Progress in the documents created during that process.
Okay, let's move on. Court ruling, decisions create uncertainty. Actually, no, let's talk about ORC. The part about like strike down, just because they don't listen to it, why would they strike it down? Where does it say
The
they would strike
argument is
it?
they would strike it down as not valid good law.
Okay, wait, what?
The argument is it would strike it down because it's not valid law.
Why does that mean they strike it down? Like it's, actually, no.
You said plan solves by part, what's the warrant?
The argument is that people would be united over the passage of the plan,
But why? Like what evidence says they would be united?
because the government would pass the plan. They're all united.
Like why does it mean people would be united?
Because you made the argument that people doing a single thing is sufficient to solve bipartisanship.
Okay,
That's
so
true.
things like polarization in the status quo, like extremism, how does the plan just unilaterally solve all of that?
Well, I'd have the same question about your internal method.
Well, yeah, because the campaign is a process that solves it.
Right, it's
What
a
about the
process.
plan as a process that solves it?
Yeah, the process is being voted on and it's unanimously voted on by Congress.
And code, you didn't say burn the both?
Say what?
On US code, did you say burn the both?
The ORC counterpart?
Yeah.
Yeah.
You didn't or you did?
Actually, I didn't say the words.
Okay.
Okay.
Yeah.
Okay, I'm good. 843. Possibly.
Did you write it down, Ross?
No.
Ross, did you write it down?
Yeah.
Okay.
Or actually, wait, this one.
Oh, okay.
Y'all didn't read Megacities Impact Card, right?
I marked it.
Okay.
Should be marked, but it's in virtual.
Thank you. Keep
Okay.
going. 824. I'm gonna go fill some. Okay. Wait, did everyone get it?
Yep. Let's see what
Common law, CSR counterplan, US code counterplan, licensing, reorganization.
Sorry, 1 second.
Yep, agree.
Good. No?
Yep.
Okay.
Common law ticket, not going for a casino climate impact that takes out sharing economy, CSR, no condo counterterm. We get what we did. One, next flex, the topics that bias against certainly any industry, apps like scale mechanisms, and topic keys are scales, portal options. Our key test the affordable angles to sustain equal research for institutes, arbitrariness, non-neutral theory interpretations. Our race to the bottom, which counts as substance-based. Our defense must use notable T case distance, P, 2 dimension utility. Adding more efficacy results in strategic liabilities. 3, straight charging enforcement, counterplus. 4, infinite point check on use. 5, project the argument. Punishment if the crime, concede versatility from T, make the counterplus dispose out with consensus. There was none. 2, we can't solve. Next, force terms of theory in the 3C. Dictates the block, creates logic, putting the counterplot dodge, include the affect for creativity, angle fallback, causes innovation and force the affect to count the 1AC to be generic, spot is linking teams, carrying the benefits that lead to counterplots because the affect can see the US code, the counterplot solves the whole case and revises a title to clarify the plan. The code is technically a non-binding summary of law that's perceived by all lawyers, courts, litigants, and authoritative designations of eligibility are governed and spelled out by Title 17. That's Harper. The result is identical. OLRC qualification is misperceived as binding law. Show 20. A law negotiation in enactment code. OLRC is the power of courts, litigants, public interpreters. Is the code is Congress law. Looks only the code ignores statutes work assumption as code is accurate. The OLRC as a distinct laws is incorrect. The difference is not in order to prove law because listening and time consuming non-positive law. And then ambiguities ensuring appearance of perfection. Air neg. The counterpart is good enough, even if not perfect, here relative to the steps quote of the plan. Nobody knows the legalese, so it looks like definitive clarification. Perm blank 1 doesn't solve anything. They haven't explained it, and it doesn't spill over. But if they said do both, it links or it's severance to the mental law itself, which requires congressional enactment, or judicial decision beyond the OLRC that triggers fights and destroys the perception of partisanship necessary to shore up legitimacy that's crossed. It's also mutually exclusive. The counterpart says without expanding IP law, do the counterpart severs the voting issue for clash on that ground does not protect trademarks. US code is technically non-binding, operating solely as a clarifying instrument that summarizes the law. Any later uptake is by effect and based purely on solvency, not mandates. Code is a fundamental alternative form of law that's crossed. The card does not say that it's positive law, just that it contains some statutes, which is not the same as it always being statute. The forcible law for federal trademark rights originated from the Lanham Act. Otherwise, they are merely common law marks and limited to geographic origin. So, right, actually, direct collection of the common law system made limited orders to geographic areas in the scope of protection of federal trademarks. A federal trademark is completely valid and the mark is supposed to be exclusive right to the US in terms of federal law trademarks that primarily govern the Lanham Act. The different source law might be different governing statutes. And then preferred non-enforcement destroys groundways by convenient links and soft law exposed limits into infinite procedural treats or guidance. As certainty is 0. The optics of the counterplan are identical. US code looks authoritative, and even if not, it will be miscited and erroneously codified as law. That's crossed. They dropped the second plank. We forget the executive, and courts defer to the OLRC's interpretation, so nobody contravenes the methods. It links to the case. All statutes are implicated in the code. Look at once the statute enacted OLRC, to be certificate about provision of the US code. No impact. Some uncertainty is inevitable due to constant litigation. 95% of their evidence is outcome is key, not process. This includes a clear message that's viewed as indistinguishable from hard law. Stack 19. This codification takes place in the culture. The code is shorthand for legislation and advising. The percent of the code is legal citation of the from public audit only. Code is a discrimination about the community. Is there authority for identification like these the same codes? Just the lawyers of financial ratio based on the code. Listen to the briefs and advices. The person that overlooked is vast. Then they said authority. The OLRC is an expert at code revision. 170 implementation center requires the section of the code that's the organization allows to accomplish because the OLRC the responsible for implementing the integrity of the code and classifies laws that code changes in the wording enable the reader to navigate or see its rules and concerning and ensure that a drafting interpretation definability. And they said strike down. The card does not say strike down anywhere, and Congress routinely translates the code into positive law. As R15 code becomes opaque, given the frequency of parties just that US code, the code is preventing evidence of statutes of the official statement. The bills no new law and actions presume that Congress convert the code to controlling the title when it's codified. Allowing me the OLRC reviews recommend revision of the title and recommends titles for codification. Also sure that existing title constitute no attention to laws when enacting legislation. Now the delay perm is intrinsic and that's temporal separation between the counterplan and plan. Even if each can be delayed, that's new sequencing. That's fiated by either. Rejected. Intrinsicness destroys all ground. It's constant all means. Despite time-sensitive or age-specific DAs and prevent education about real-world net benefits. Independently, the treaty did not include a formal text, so you should scratch it. It's impossible to make severance arguments or read DAs since they'll shift the perm in the 1AR. Prefer a delay despite science fiction destroys timely education and spikes ground. Worst-case examples do not apply. The delay counterplan can be excluded on theoretical grounds or being with a time-sensitive advantage. The counterplan team polarization expanding the OLRC's role in lawmaking, mainstreams expertise and independence by devolving power to a non-partisan office. Congress can punch on thorny questions of authority and leave the OLRC to take the fall. It creates a conflict resolution mechanism that acts as an off-ramp for hyper-partisanship that's crossed and dropped and not there's no word. In the 2C, the plan cannot solve bipartisanship. No explanation. People be united is not the same as government polarization. That a benefit outweighs a magnitude polarization unleashes existential risks. Drop partisanship ensures ground is failure. Overwhelming congressional responsibility to crises like climate change, will spread or nuke war. That's frontline. Now the other issues from it's intrinsic. The counterplan only clarifies the trademark statute to include the plan, nothing more. Counterplans must be functionally competitive. Prefer it. 1. Ground. Plan specific and eliminates all generics and a possible burden against who asks that destroys fairness. Germanus is meaningless will shift to encourage small cases that dodge class. 2 is logic. Potential combination distorts opportunity costs. With semantics and planned sophistry, independently functional justifies functional severance, which make the alpha-moving target and prevents testing. No abuse. They're guaranteed ground because all counterplans are distinct from the plan. They speak last and have infinite effect to find deficits. Air neg. Any limit for intrinsic distance is arbitrary. No snowball to engulf whatever he did. Independently, it doesn't solve because of vagueness. Number 20. Approximately with political startles not. Equality policy in general transfer by zero. Let's see certain LAC has a party for standing goal. Seeing not present himself and not a direct relates progressive vision, not knowing a particular person. Inconsistency can be found. Licensing. Cannot solve. This is not the plan. They don't protect licenses from issues that occur when trademark owners go bankrupt. Additionally, all causes being a part of IP law clear does not clarify all of IP law. They do need to solve all clarity. They said that full certainty in every license agreement is key. The status quo solves. Licensing agreements obviously exist now in the number of businesses that might go bankrupt is minuscule and are not producing economic value. Their sign card says they're inevitable extraterritorial infringement. When companies expand abroad, trade is not so boring. They cannot prevent international crises, and people that want to escalate will do so inevitably. Not everyone relies on one another. No trade impact there. 22. Trade not enough to explain peace. Effect is small. Benefits of trade US was 1%. 150% of GDP just larger than war, but trade timing arrivals of influence that float long time distinctly. Trade GDP democracy and international law is a difficult trading estimate. Oversized. Now the sports policy impact, no internal link. Lead does not explain why bankruptcy rights are key. Their impact their impacts have no link to sports diplomacy. It's just an example. Make them explain how they solve warming. No impact. Soft power always fails. Small countries will always ignore larger. Like culture and existing problems, which always that way. That's Fineco. The education impact. This makes no sense. People still attend college if they don't have strong trademark. They have to win all forms of education and no guideline for how much education is key in their global causes, like uneducation in other countries or other countries fill in. No explanation warrants new answers. Reorganization. No solvency. The plan does not build them out. Only allows them to end licenses when bankrupt. COVID and away thumb. They are not app examples. They do not cause extinction, which sums the impact. The plan does not cause war. 120. I don't think economics in a war will cause there be more. US 40 recession, 20 wars unrelated, legion war, where when you be long and uncertain, no matter the income will not. The war against achieve with successful motivation and security of course started the of content. Economics are one factor and rarely a significant decline is peaceful. 40 recessions cause wars, and most wars are unrelated to economic conditions. Leaders turn inward to resolve domestic conditions, and wars too costly and bloody to pursue. That's what the sharing economy impact. There's zero evidence that those startups who go bankrupt are actually key. Other successful startups are bad. Saving to unsuccessful startups creates a zombie market, and it cannot solve company attitudes of not caring about the environment. The impact card does not have a terminal. It says poverty, which will answer, and we also conceded climate environment defense from common law. Innovation responded very catastrophe lumber. 21 appendix on more digital humanities overcome large effect. 23 our place should be solved one of the many. Humanities showed climate small innovation. Will help us know inequality impact. The effect is statistically insignificant. Must 16 does inequality lead to conflict study? Where the circle to establish relations with minority who rebel, not the whole population study. Measuring inequalities, people take action with the perceived injustice rather than measured inequalities, not work any. Completely decide how inequality led to perceived. Cross analysis of political perception analysis data in 1989 to 2014 finding objective economy. Inequality is not of any significant effect. The populism impact. It'll be stopped by both international and domestic buffers. That's not. It's also self-correcting, proved by 800 elections that strain bureaucratic institutions. Prevent it. Illing 17. The president unilaterally strike no these smart amounts of the and assess monitoring and even events and protocols will do these other scenario. The president said they want to strike and raise length through the chain of command. They're trying to disobey orders of conduct matters. They're striking no contact controller. Order exclusion of chief of staff is joint seats that would hold the process cut the card. At process, civic engagement is high. There are also global causes of civic engagement high. Best voter 23. Posting country find community social media and trust voter civic activities. How been politically after 1/3 is a group that turns 26%. Encourage others to take action.
Cut that card at action.
Okay. You for us.
Yeah.
Well, starting to have an how does polarization cause nuclear war? How does polarization cause nuclear war?
So let me pull up the Brundtland card. So this card says that having sort of political cooperation in the government is important to be able to resolve existential crises. So when Congress, the courts, or the president are trying to work together, political polarization can mean that they can't effectively do policymaking, which is key to resolve like a bunch of these existential crises, such as tyranny, war, WMDs, disease, climate change, etc. And it says that having nationalism, partisan politics, etc., make it impossible to tackle those threats.
Which is not polarized solve for, I mean, actually, what scenarios for nuclear war do you think?
I mean, we think that strong U.S. policymaking is important. Obviously, like, there could be thousands of scenarios for nuclear war. Like, a bunch of countries could lash out against each other.
What policies would we have to make that require all three branches?
Well, it's not just about interoperability. It's about, like, partisanship within branches, too. But, I mean, any array of policies that we have to pass. Congress has to do things, the president has to do things, courts have to pass rulings. All those things come together to do, you know, probably good things. I mean, they're supposed to.
That makes sense almost. The
So you made the argument about the second sentence in it, like the courts and agencies defer to it. So I guess how is it perceived as credible if the courts are citing like the spark notes of U.S. law to justify anything?
So that's the card that I read under the solvency header. The show card says that clarification, even though it's not binding law, is perceived by the public and by the government as binding law. So they think that it is and they'll act as it is, even though it actually isn't.
Which one?
The show card, and also the cards under certainty and the cards under ORC and codification.
Oh, the
All
top.
those cards.
Okay, cool. I guess the show card says that there's law undergoes change and at which point the ORC can modify it between enactment and when it is organized within code. Which law has been enacted but is not yet organized in the code that you think the counterclaim would address?
Title 17 of the U.S. Code is the version of the Lanham Act that's in the U.S. Code. The counterplan inserts a provision into that which clarifies the same thing that the plan would, that licensees can reject trademark agreements sort of in the same fashion.
Okay, wait, so it inserts a bankruptcy statute into a trademark code?
It inserts it into the trademark statute.
Into the trademark statute? Okay,
Yeah.
wait. Alright, sure. And then,
I mean, it doesn't
the
really
spillover
matter where it
argument,
is.
or I guess the do-both argument, I'm confused why it links to that method.
Okay, so there's a few things. First is that it's mutually exclusive because the counterplan says like without expanding IPR law. Second is that do both amends the law, which is the reason that we've said it triggers partisan fights. That requires Congress to do something or the judiciary to do something, which is beyond the scope of the ORC.
I'm gonna run to the bathroom real quick before I sign up order. But if you want an order, it's CSR.
Did you send it already?
No, I'm gonna send it.
Okay, that's fine. I'm gonna take some.
But
Actually, no, we'll wait for you to come back.
Yeah.
And Ethan. We're at 5:46.
wait, do you want to take how much more? Setting up the order. It's gonna be advantage 2 wherever you float the add-on. Then the CSR counterplan and the election CA.
get the order again?
Okay. It's like Advantage 2, wherever you put the add-on, then CSR counterplan, and then elections, yeah. And everybody else is good?
Yep.
Yeah, Peninsula?
Yep.
No man can see the impact when you concede the impact even to the environment which zeros the impact because of sustainability, but sustainable cities fail methods. When one considers today's concerned about privacy, what takes to answer the backlash against companies to help them spur the movement, contributing counter cancellation project and aside economic certainty, the smart city would be scrapped from COVID. To stall a momentum now, marking kind of momentum, the CSR kind of picks are good, key to fairness and then blocks because he's deleting all kind of it. Because anything could be a pig, concede feasibility from T, which uses offense projecting the argument on the team. RC is not a pig, it's an Asian counterpart. Now, the elections, yeah, Eucharist isn't fair outweigh new Trump 2.0, triggers hasty international relations, stops the green light, global turns fair. That ensures tense relations, the bull from the blue, global wars from Korea, China, Russia, and Iran, which has distinction that spares escalates every hotspot. That was about Trump's case, and only Trump is conservative, and he hates bailing out companies who roll back the plan, unite on presumption, and crushes every one see impact Trump makes. The U.S. law look uncredible, hurting diplomacy, and publication, education independently does a bunch of tariffs, which cause inflation and crashes the economy. He also suspects populism because he has a huge following. Now, 281 Harris wins now. She's led by 3 to 5% nationally, allowing her to score the election, but that's a small margin. It's currently stagnated, so any shock could throw the trajectory off. It's short. Prefer our evidence is from October, theirs is only from September. So I'm not reading any new cards. They do not get new cards. And the 1 year now the link, stronger IP throws the election to Trump is egregious flip-flop that reverses Harris' established position on IP law. Democrats historically supported government margin rights and have taken a hard stance against corporation IP that's entry, especially because it allows bailouts a company through trademarks, which is perceived as saving big tech companies and causes a huge flip-flop. She'll lose immediately. Scopage 24. Harris announced progressive policies a bad policy in 2004. Dominant short-term carries are not political property as opportunists. Change position of political convenience, making it hard for voters to trust what you're saying. Moving to the right. When I prevent Trump from attacking Harris, it's a dangerous, about to use of policy. Although the boys second line is actually untrustworthy, doesn't keep a consistent position. There's widespread and bipartisan anti-corporate sentiment. 1022, public views of large corporations come more toward negative institutions held low and seen 26%. Republicans 25%. Democrats say the large corporations have positive effect on Republicans. Assessment becomes more negative. Republicans make more negative opinions. Tech companies. Now, you should err negative. The election is less than 2 weeks, and any tiny shift in the electorate could widely swing the results. That is especially true because of October's rise, which I'll explain below. The next argument, 262, it flows now. It's out of the blue and terrifies voters. We have evidence. In October's surprise, flips the election. Zucker, 10-5, Constitution, Trump and Harris says, bare knuckle, overall, White House said block the victory was decided by slimmest margins could be an event out of the controlled unconstituted authentic campaign surprise. I drop in October to think he'll wait emails to time left to recover. After misstep, there's no room for error. Lofton, 10-3, Harris and Trump locked in a time response. There's no race within, no room for error. They see 3, no evidence that Trump cheating will succeed. It also just says they announced a new program, not that it's working. 4, reject intrinsic and test is rejected ground on an abside topic because they can test any test out of any DA, which also allows extra topicality because they can get new advantages off to 5. The card doesn't say no one cares. It just says people are currently focused on current policies, but the plan is a new policy. The people would obviously focus on links are magnified because it's a bolt out of the blue, flip-flop, and near election. It doesn't mitigate the link regardless of whether voters care about IP. The Trump administration would use the opportunity to call Harris out for switching sides. That's scopish. If we can win a low risk, there are millions of undecided voters in swing states. So any significant shift is significant because that will tip your ballot, tip their decision on whether or not they vote for Harris. The polling is shifting every day. There's hundreds of millions of undecided voters. Swing voters are real. Look, 24 voters who dislike both parties played a majority role in the key elections. Our points of pivotal this year, the result could tip the election about rights voters. Identities when not closely tied to politics, offer grabs are persuadable, they certainly exist, and largely looms on close elections. Swing mode, the threshold for the link is low. Core 24 contest likely to be determined through vote less than 1% 7 states where the margin of victory is under 3%. Georgia, Pennsylvania, Michigan, Wisconsin, Arizona, Nevada, North Carolina, 10%. Voters undecided 3 mode. For guys, the effect is robust. Yup, 20 there. Is there a swing vote? Yes. 10% seems small, but in a close contest persuading as lower votes and key and swing groups to make a difference. If they're right, the election still flips. Voters will see Harris as a priority to something that doesn't tangibly affect them. IP workers are immensely popular. McCardle 21, waiving IP for coronavirus must be popular. Trumps and voters associate IP with high drug prices and corporations. Baker 16 recurring. Because of this, I claim the likelihood of large segments of the workforce, the robots will take job tech, benefiting people in college degree sentiment of less education, declining wages, and continually rising inequality, technologies, and corporate laws of patent IP. Record card at IP 366. No card of study says people will just forget. People remember things that are close to like IPR, which is proven above. No checks on Trump. 367. Trump circumvents in Polina. 24. Trump has the unilateral authority to launch Anuka, Eddie Mama Chaka, and the words of the called approvers not needed. Secretary of Defense cannot stop with order Chaka. I stated a system and bill proceed whole process takes minutes to discuss. The idea of using a new position as employment is like on another country, yes, popularity. Of course, in Congress are a conservative majority. Trump will curb debt, but nukes don't require increasing it. What? He also has a strong nationalist backing, which proves public support. If they can see populism defense, it's insane because Trump is more aggressive and he's not just a populist. Advisors, Constitution, Jackson 24, China, a Hawks prodigy calling for a regime change, raging that a 10 cents of dollars deploying a Bahrain, course in Asia and new protecting an Asia started private care, adding marines is likely to cause war for unlikely we end up with station new protecting in common path. Armageddon!
Five oh two.
Yeah.
Licensing, mobilization, or not mobilization, reorganization, ORC, elections.
Just down. Okay, I'm good.
Okay. Anyone not good? Carl?
I'm good.
Okay.
The price also gives licensees rights explicitly. This was a discussion in the process and says that they can gain this trade trademark if they quality control it. No, we don't need to solve our IP because the only reason why they've deterred is because of bankruptcy. The status quo does not solve is incoherent because licensees deterred since licensees can get fucked over right in the status quo. Only the plan can clarify them. It's not inevitable because international licensing regimes can be reversed if they can just go abroad and have licensing, which is what's being deterred in the status quo. There's no escalation. Inevitable trade stalls is about the perception. Even if trade overwhelmingly does not cause conflict, first they drop the cabinet evidence, it's better it causes. It analyzes all studies in its most recent assessment. What has not happened since 1945 because of trade. Second is that it's about perception. A lack of trade perceived makes the US perceived as protectionist and unwilling to cooperate internationally, causes war because it exacerbates resource insecurities and causes other countries to avert multilateralism, which allows them to start wars. Licensing is the key internal link sports diplomacy solves every single conflict and polarization by causing countries negotiating with each other international problems to solve. By sports diplomacy, which was mostly done above, it's not about small countries, but large countries also cooperating with each other. Advantage 2, economic decline has dropped the cost of extinction, which says never evidence is not about the last shot, but rather when other countries perceive the US as weak and invade, it's more semi-hedged impact drop index. Evidence is about the geopolitical status of the world in the status quo, and COVID and 08 don't dump because they doesn't price in the status quo, and those were okay because the Chapter 11 reorganization allows us to reorganize these 2 years. And then with outdated post-COVID is unique, numbers don't apply. We can pull out a status of recession where Chapter 11 reorganization and class concludes where it's still possible. Watch money on cannot rely on the world. There's some countries we won't see where this. Some countries know the blood they can see population defense takes out the impact of both the positions. The ORC counter plan. They do not solve drop the authority. Deficit requires law is first. You cannot recommend something that does not exist. The show evidence concedes that requires law to happen first. So no one, so that the ORC cannot roll into something that doesn't exist in the status quo. It's a flaw. You have no idea what they feel because trademarks is literally omitted from bankruptcy code, which is the entirety of the 1AC, and trademark code has nothing to do with bankruptcy. So there's nothing for them to rule on. Lanham Act is decades old. No one checks new knows inserted or know that they exist or know the kind of what happens. No new answers. They don't have the ability to inject new studies. Only insert notes into existing law. No one perceives the killing 2289 of dispute controlling or without appears in the negotiations and laws not possible. Reflect that the negotiations consequences in private commission or Congress course not considered OLC or prejudice of Congress and meeting amendments, specifically in legislation. Thus, no one will perceive that as true. Licensors and licensees need certainty in order to conduct licensing agreements and to do reorganization that influences the strategies that to call and concerning evidence in the 1AC. Otherwise, they have no idea what to do, and that ducks reorganization and means that they're showed from entering into licensing agreements. Permanent to the counterpart, it is still law. It's the same thing. Just code. The code not being enacted. Non-positive office and office. They have dropped that non-positive titles are still law. So ORC counterpart. This proves that the counterpart is literally mandating the entirety of the plan. It mandates the law. The plan is signed into law as code because non-positive titles as the ORC's recommendations are the exact same as law. Now, our interpretation only to class out this one counterpart, so all their defenses solved by just reading a different counterpart that competes off of mandate. Actually competes off of mandate. The Lanham Act is not a definition. It's a description of the status quo. It doesn't say that. It is not trademark protection if we don't do it through the Lanham Act, but they insert it into Lanham Act anyways because that's which exists, which proves that they have to edit the law anyway. Prefer it solves all their options because it's only in this one instance. And this counterpart deletes every single aspect of it because they hard to conceive about how it's perceived as law explicitly, and they fiat the other two branches to comply, which also should be enough according to the counterpart argument because they fiat that they complied with the executive plan and fiat follow on, so there's no chance for the affirmative to generate deficits makes it unavoidable for the affirmative. That benefit, the counterpart obviously links to that benefit because everyone perceives it and flips the election. No internal link, one see cost. This is to the various congressional bodies and how they all contribute to nonpartisanship, not just the ORC one instance. Definitely this has to spill over because there's no warrant for how the counterpart solves polarization quality because no population impact takes it out. And warming defense takes it out as well. There's no precedent because they frequently issue clarifications. One single conspiracy kilometers and active 27 titles into positive law to 27 additional types of medicine. On Title 42, this had no rollback. Fiat solves all of their often Trump is constrained 4 years prove that Congress has avoidance of bureaucracy constrainment as it cuts evidence. Fiat means that Trump must enforce the plan. Any other interim means every ask uses to rollback them. So in the House they need to try that Trump can do anything without them rush with. 417 insert the chart grouping this one Trump will be constrained to the Congress 1 yes. Sitting check analysis Trump was on through. We found that normal procedures conflict order they see it. In total wars acting in a lot of block by course where the Congress is debating Trump speak. I try to believe the efforts to not get Congress is debating. Or somebody's contributed of this way proceedings 100 centuries. Take this promises with a grain of salt. Now, the plan is on the team of big corporations. There's no link. We have read internally about small business help and how the plan helps them license, but no one cares that flip off because it's not even anything about bankruptcy code and status quo. There's no reason why they perceive the status quo. And the plan IP the cards about IP are about waivers and all about patents, which means that it is not related to the plan or about bankruptcy. It proves that every single all cause matters. The plan will not flood because inflation, Gaza, etc. All are way too more important. People are locked in anyways and care more about those issues. So even if October surprise matters, one, that's about October 1st. Now it is way too locked into the election. We have no cards about the status quo. And two, and that they will split right now at this point in time. And two, even if they're real, that is completely irrelevant because the plan doesn't flip and they care about the other issues. 3C3, Trump wins in TGC election. We have a card they do not. It takes out literally everything because our card says that Trump will flip. He hires 10,000 voters to take out everything and count votes for himself. That causes election fraud and flips the election in favor of Trump. They have no card to say the otherwise. And yes, of course, it doesn't say that it has succeeded already because the election hasn't happened yet. Trump initially destroys victory, which is solves the impact. Also, not only drop warrant, Trump still wins now with statistics. Evidence is 50%, which is the DA must start at only 50%. Harris must lead decisive, which the evidence is concluded.
I don't have it yet, so.
Yeah, okay.
Got it.
Peninsula?
Yeah, got it.
Okay, panel?
Trump 2.0 is an aimless march towards extinction. He immediately severs ties with our closest allies and pulls out of alliances like NATO, sparking global deterrence failure. This is not even slightly close. You cannot justifiably vote affirmative when the one of your jobs turns case, warrants for the link, and warrants on uniqueness. Evaluate the DA first. One, scope, lack of effective deterrent, causes war in every major hotspot: Korea, China, Russia, Middle East, Venezuela, and India, all around without the threat of US retaliation. Two, immediacy, pledge to act quickly towards its extremist goals, and every other leader knows that Trump is worthless. His America First policies are irreversible and will cause lasting damage. That's all bears. That shreds the case. Trump immediately guts every Harris-era policy. He'll appoint accountability parties and executives that will choose not to enforce it, and appoint justices to rule in favor of cases that hurt solvency. Drop. Fiat cannot solve this. It's not rollback. Just the idea that Trump would try to reduce how Kamala's policy works. They drop, turns case, diplomacy. Trump thinks this looks incredible because he threatens allies. Education, conservative, super anti-public education, which side with it, and he's also pledged to abolish the Department of Education. Recession. Trump introduces tariffs that increase inflation and decrease productivity. Populism is a huge following that listens to his every order. No impact defense. They basically dropped every warrant. No checks and balances. One, circumvention. He has unilateral authority to launch a nuke. Even the Secretary of Defense cannot stop him. That's Kalina. Two, advisors his cabinet sides with him. And also try to launch nuclear wars of aggression. Drop examples of potting a Marine Corps, Miller, etc. who are all military hawks like Jackson. Three, the courts and Congress, they both side with Trump. They're all conservative and are pro his policies. No groupthink. This is the exact same warrant, but even worse. The part is about legalization, like legislation like affordable care, which is distinct from a nuclear strike, which can be unilateral. Executive action. No populism defense. The 1NR explicitly preempted this. They dropped that Trump is more extremist, not just a populist, but is willing to launch nuclear strikes. You have specific evidence about only him, and it's also about other countries lashing out. Choose that populism defense cannot answer it. The link debate. Frame this through the current moment. It's less than 2 weeks before the election. Harris cannot take any chances, especially a massive flip-flop on reform policy. That's Kilgore, and Laughlin. The Democrats have historically pledged toward public innovation, and if you're strengthening corporate rights, that's Henry and Dunn. Drop. The plan is the October surprise. It's the last minute change to the law that looks like Kamala's last-ditch attempt to get more votes. That backfires. Voters see the unannounced flip-flop is Kamala being untrustworthy and unpredictable. That Zurcher and Skopik also dropped. Specifically, IP is a hot-button issue. It defines group identity, and voters know that it correlates to economic well-being. The recent anti-IP sentiment has culminated in voters perceiving all IP policy negatively, regardless of its actual effects or contents. That's Whitland. Air neg. Republicans will spin any move Harris makes into a negative. Less than 2 weeks ago, every move must be calculated. The threshold is low. The 2000 election came down to less than 100 votes, and current projections say that a few million will decide the election. That's Kilgore and Laughlin. Just a few swing voters will decide this election. That's also not answered in the 1AR. The threshold for the link that we have to win is very, very low. No uniqueness. Frame this to recency. We're the only ones with evidence from October. Harris has a minor lead by 3.5%, winning the election, but it's a small margin, and any change of policy will throw it off. That's why they see premature declaration. One, they dropped that they don't get new answers because the 1NR did not read new cards. Scratch it. They don't have a justification at all. Two, this is describing disinformation to Republicans, which many of them already voted, but the link is only about swing voters who haven't made a choice. Three, none of this link of this card says that disinformation works. Four, disinformation fails. In Ostrowski 23, in Luke data, disinformation went to the flag crying, but chronicles assume that because attacking hypothetically available, the attacker is using it, but actually face budgetary and time constraints. Cut the card at constraints. Now, every other cause is priced in. Inflation, Gaza, etc. Every voter that's voting on these things has already made up their minds. They're not answering the fact that there's still millions of swing voters that are affecting the election. And then Trump will not flip the election. It's new in the 1AR. So you should scratch it. They dropped the uniqueness cards from September, which is long ago, and we have the most recent evidence. It also does not indict our card. We have more recent polls that the card does not assume. We also cited the Moody Index, which is not what their evidence is citing. US Code counterclaim, KK can see the perm. I'm not going for it. Licensing. Solvency. One, they cannot solve uncertainty. Nobody knows what constitutes quality control, and the plan's vagueness makes it impossible to enact. The 1A does not explain this stuff at all. All it says, the plan gives licensee rights, but never explains why this is clear or obvious. 1AC cross-ex proves this, and it was a crush. Two, this is important. Clarifying part of IP law. IP law does not clarify all of IP law. Their internal link is about all licensing agreements, which means that either the status quo solves their impact, or they cannot solve it inevitably. Every licensing agreement now that exists now disproves the impact. Most licensing agreements operate fine. They have no evidence that companies might go bankrupt or produce any economic value. They said only deterred because of bankruptcy. This is not the case for every single licensing agreement. That only means the status quo solves 90% of its impacts. Globalization. They will never be able to prevent international causes like the ship blocking the Suez Canal or other countries lashing out against supply chains. Trade does not solve war. Causality is a whiff. You're trying to trade is 1.2% of GDP, but it's super independent. GDP, democracy, and international organizations determine the direction of international relations. They said perception. What? This is substantiated? Nowhere. And Thumbers prove it's terminally denied. Sports diplomacy is a joke. They cannot come close to solving it. Their internal evidence never explains how bankruptcy is key, and the small country versus large country distinction is relevant because our parts of the great powers always counterbalance each other. Reorganization vanished, solvency is dropped, plan does not bail bankrupt businesses out. It only allows them to end licenses. They're not able to actually generate the money to get themselves out of debt. Economic decline, COVID and 08 are not priced in. They made no distinction between the current state of the world and the world literally 4 years ago. They terminally denied the impact or prove it's inevitable from future recessions. The Walt Indite, I don't know if they read it, but this is about a global depression in the Treaty. They said the relative decline, no takebacks. The rewards strategy, Truancy Walt explicitly says that economic decline cannot cause war and will never cause war. It also says the recession is inevitable and that there have been over 40 recessions that are not correlated to any form of war. Conceding capitalism does not matter because our picture that Trump will lash out against the world.
Whoever's going to do the reorganization manage the licensing manager decide. Anybody not good? Cool.
Economic decline causing exchange which says revisions issued like China, Russia, is stagnating growth as a signal of weakness and opportunity to initiate nuclear conflict. It is faster than the disadvantage of impact based on the perception of decline, whereas impact is inherently long-term. Trump first needs to be elected in the election. He has to be certified in January before he even has a chance to do anything. He has to build up his cabinet and gain popular support among all three branches and the public in order to initiate his brinksmanship. He has to coordinate the entirety of the GOP, has to be perceived by other countries, and then would have to initiate a nuclear first strike. It also turns the disadvantage. Inflation is a bigger hotline issue, which has been our bumper argument since the 2 weeks that they failed to grapple with. Planning to do the plan would flip voters who have it as their top issue back to Trump, which means that the affirmative has influence to their office, but they have none to ours because they just asserted we dropped free speech without grappling into any of the one year's arguments. Framing case to the fact that you're asserting massive economic collapse is coming after the concession of our internal link arguments. Over half of our financial assets are invested in a sector rapidly barreling towards collapse. Only the plan solved by enabling these large franchises to reorganize their assets. That means the scope of the internal link should frame their defense. If the entire banking sector is about to collapse in status quo, that is far worse than any empiric that their wall evidence or that their empiric their empirical numbers could possibly cite their defense. It's all wrong. I'll answer their argument about companies going bankrupt made on the first advantage. These companies do have economic value. Are evident. They talk about 1 ACM, which has been said in every speech as the commercial real estate debt is what has over half of banking loans in the status quo. It certainly destroys the banking industry, which they conceded in every negative speech is sufficient to destroy the entirety of the economy. There are solvency arguments for it. There's two arguments here. First, is super gloomy the 2AC, which means 2NC, and extrapolated new in the twin army, which means you should give it very little weight. Second is they dropped our argument that we would bail them out by allowing them to reject licensing agreements. That is the key thing that prevents them from engaging in Chapter 11 reorganization now, which is the only thing that can prevent complete economic catastrophe in the United States, which is all of our cards on the second advantage being shackled to their licensing agreements, which raise too many resources in order to do quality control, which means they are unable to reorganize their assets and come out of Chapter 11 bankruptcy safe and sound. Their numbers are all incorrect. They obviously are pricing. COVID was not relative, which the 2NR agreed is what our scenario is about, and OA had Chapter 11, which has been our argument since the 2AC. Argument about the argument about Walt, the dropper indictment is about lash out, which the yeses are drug evidence, but it's not our sharp evidence, which is the scenario I'm going for. It's about the question of global perception, which was dropped there. The scenario only examines instances where the U.S. initiated conflict that is irrelevant because we are having conflict initiated with us, or which our evidence is specific to conditions in 2024, which means none of their empirics should apply to this. So, citing this, the first advantage, concede defense, I'm not going for it, which takes out any office they might have. In the first case, the disadvantage, Trump will cheat and win the election. You can go down on presumption because the 2NR flat dropped the argument. The only thing that's 70 responses we read unique because that argument does not answer what we go for. Obviously, Harris winning would be now because the election not happened yet, but Trump so easily flips the election for himself. But putting 100,000 people to county house and literally committing an election fraud, even if our card sucks, it at least makes the argument. Trump is 100% committed to winning by any means possible to securing a victory. So you're sure, regardless of the plan, that the status quo Trump can cheat and win. That's our limb evidence. This, even if they were to, the disinformation argument is completely wrong. That's not important in our evidence because it's about Trump appointing ballot counters who will cheat and insert fraudulent votes. It's not a question of what the public believes, but rather what his corrupt appointees do. Even if they were to win unique, this doesn't matter because at best, because their 1C card that is the only card they read on this caps, their caps the win chance of Kamala winning at 50%. That doesn't mean she wins by 51% now. It means she has a 51% chance of winning now. That's an important distinction because it means that you should cap the disadvantage at 50% before even evaluating the plan versus the disadvantage. Impact defense takes out their entire term space, which they don't have a single war that's not Trump can his biases can launch new tariffs, go back and enforce every other aspect of the impact applies on Congress and courts. They did not answer the warrant for the 1AR. At least answers Trump's case. Congress prevent Trump from passing any policy wants and courts are listed, and still other executive agencies constraining literature for cuts in our 1AR argument. Still, there's no unilateral first-rate argument. First, no evidence that he can launch nuke by himself or that his advisors will let him. Every argument was about alliance commitments, not unilaterally launching a nuke. This is literally the inverse. This means that every war leads back to our defense because Congress stops him from doing anything crazy. Isolationism would not suggest going to war, citing this logic. Trump cannot declare war because it's Congress's power. They drop the 1AR evidence. The Democrats will win the House. Trump cannot withdraw from alliance or abandon arms control because Congress controls all. The 2R analysis here relied on winning that he has control in all the parts of the House. But empirically, when the president does not have control of one House of Congress, it creates gridlock, like what happened by Biden. Regardless, the link is quite literally zero. Here, the first argument is numbers. When 2AC balls evidence indicates that every swinging voter has already made up their mind on a far bigger issue. Things like Gaza, inflation, Ukraine, etc. are all way bigger. When people are actually dying, who gives a fuck what corporations are able to do with their trademarks and bankruptcy? It's such a small issue that none of their evidence could possibly speak to. The framing issue should be specificity. They might have evidence that IP broadly is a contentious issue, but it's not talking about trademarks. It's talking about things like patents. And even if they would win that IP is a big issue, they dropped that it does not comparatively and that it does not compare them to our numbers. Even if it's true that people care about IP more now, they don't care about them politically, and they don't care about them nearly as much as things like the economy. Even if they care, it is still like 20 billion on the list of what voters care about. Second is it's too late. Their October surprise argument certainly feels affirmative. If you read their blog cards, they're all from the beginning of October. Sure, we had the entirety of October for something to happen, but now it's too late. These voters have made up their mind. They already know who they're going to vote for, and a small procedural change, but they have no reason Kamala would even get tied to because of the Republican House who would pass the plan. It's certainly not something that would be sufficient to flip it. This isn't a closing argument. It's a procedural thing that Congress would simply be passing. They have no evidence that's about bankruptcy or trademarks. They have no evidence about IPs not compared to our numbers, and numbers certainly outweigh the risk because they're capped at 50% and they drop terminal uniqueness defense.
Good debate.